You're not happy with your court-appointed attorney? Well, come with me and I'm going to explain to you what you can do about it. There are three principal ways that you can get another attorney in a Child Protective Services / CPS case. In California, you can, number one, hire your own private attorney. Number two, you can have a Marsden hearing to get another court-appointed attorney assigned to you. And number three, you can make what's called a Feretta motion, where you can try to represent yourself. You know, I'm hesitant to do these types of videos because somebody is going to take it out of context. I always tell people, work with your attorney. If they are court appointed, they have already been vetted by the court, and they are supposed to be representing you zealously. Sometimes you disagree with what the court-appointed attorney wants to do. That doesn't mean that the court-appointed attorney is wrong and you're right, but each situation is different. I realize that. So let's talk Marsden motion. In California, if you are not getting along with your attorney, or you believe that your attorney is not effectively representing you in your juvenile dependency case, the court allows you to make a Marsden motion. Now, the motion doesn't have to be in writing, although it can be in writing. And if you look at the link below, or look at the information below this video, I'll have a link to a template of a Marsden motion that you can fill out and use. But I don't think you should ask for a Marsden hearing unless you first talk to the attorney to try to get an understanding of what's going on in the case and try to work things out. Now, in some rare cases, there's some authority in California where you can ask the court to appoint you a lawyer to decide if you need to make a Marsden motion. Now, one of the things that happens in these cases is the parent says, well, can someone else make the Marsden motion for me? Like the brother or the mother or the sister, or a good friend who's not happy with your court-appointed attorney. The answer is no. You have to make the motion yourself, and you have to request the hearing yourself. And that took place in a case called People v. Martinez, a 2009 case, 47 Calap 4th, 399 at page 418. The next thing you should consider is who should be present in the courtroom when you have the Marsden hearing. In most cases that I've been in, the court always gets this right. The court should ask everyone to leave except for you and your attorney, of course the judge, the court clerk, and the bailiff. All other attorneys, including the prosecuting county counsel, they have to leave the courtroom. Why? Because certain things that may be, said by you or the attorney that might give the other attorneys or parties in the case some type of advantage or some type of disclosure of some type of attorney-client privilege or attorney-client work product or something just based upon privacy. So make sure that when you have the hearing, the right people are in the courtroom and the wrong people are out of the courtroom. The interesting thing is that the court's ruling cannot be based on the judge's personal or perceived confidence in the court-appointed attorney. This is pursuant to a case in California called People v. Hill, a 1983 case, 148 Calap 3rd, 744 at 753. Generally in criminal cases, and I relate these to these CPS cases because they're quasi-criminal in nature, you can't be required to disclose any confidential information like attorney work product and attorney-client privilege. And that's under Penal Code 105.4.6 of the California Penal Code. During the hearing, everything is confidential, and the court should order that a confidential court reporter's transcript be made, and that's pursuant to the California Rules of Court 8.328B. Also, a case in California, an appellate case, People versus Madrid, a 1985 case, 168 Calap 3rd, 14 at page 19, talks specifically about who should be present and not present in the court. So the question becomes, once you make the motion, once you have the hearing, does the court have to grant your motion for a new court-appointed attorney? And the answer is no. The court does not have to grant that motion. The court has the discretion to deny a Marsden hearing, and I'm going to quote a case, in the absence of sufficient showing that a parent's right to counsel would otherwise be substantially impaired. And that's quoting People v. Walker, 18 Cal 3rd, 232 at 238, a 1976 Supreme Court case. The parent has the burden of proving substantial impairment by demonstrating that counsel is inadequate. If the parent fails to specify reasons for the substitution of counsel request, the court may properly deny the request. When you're making this motion, you need to go in and you need to have your specific reasons listed out, and preferably on a piece of paper so that you could read it into the record and to the judge. You know, people ask me, what are some of the typical reasons a trial judge would deny a Marsden motion? Well, one of the reasons is the parent did not think that the counsel had the parent's best interest at heart. And that was in a case called People v. Silva, 45 Cal 3rd, 604, a 1988 case. Another reason why the judge may deny a Marsden hearing, counsel would not make certain motions the defendant wanted brought. That was People versus Silva again. So just because you want certain motions to be done doesn't mean that the court will give you a new attorney. The court could, based upon that and other factors, but you better make sure that you have your other factors lined up. Another reason why a court may deny is that the parent did not relate well with the defense counsel. You know, a lot of people think that that alone is a reason for the court to grant your motion for a new court-appointed attorney. It's not a basis by itself. And that was handled by the California appellate courts in People versus Berryman, a 1993 case, 6 Cal 4th, 1048. Although that case was overruled on other grounds, in People versus Hill, the rule that I just read about did not relate well is not a sole basis. It could be part of a basis, but it's not the sole basis for getting another court-appointed attorney. Now, I'm going to talk about in the next video something called the Ferrata motion, F-A-R-E-T-T-A motion. And I'm hesitant to do that because a Ferrata motion is a request by you to represent yourself in court. And in every case that I've seen in my almost 35 years of practicing law, representing yourself is not a good idea. Not a good idea. I know we can argue about it back and forth for hours, but trust me, I wouldn't, tell you something wrong. And I know you think you have that special case where you want to represent yourself. But I've gotten so many requests and questions about this, I am going to make a motion about it. So in my next video, the fraud motion, how to ask the court or have the court order that you represent yourself without an attorney or with an attorney, quote unquote, advisor. So I'll see you on the next video. Thanks for watching. Make sure you like and subscribe this channel. And if you like this video, go ahead and share it with your friends, your relatives, and other people who might be involved in this type of situation in the criminal courts or in the juvenile courts here in California.